Yeah. Salute to everybody in here. Tap the like button. We got new paperwork in the Young Thug case. They pushing to get a new bond. And we got paperwork where they trying to get Woody removed. And we got a couple other pieces of paperwork. Let's get to it. Straight up. We ain't bluffing.
Court of pre-verdict. Bond. Comes now defendant. Jeffery Williams. Renewed motion for bond and brief in support of pre-verdict. Bond. Comes now defendant. Jeffery Williams by and through undersigned counsel and hereby files this renewed motion for bond and brief in support of pre-verdict bond in the above reference case. In support of this renewed motion for bond and brief, Mr. Williams shows the below. In the great state of Georgia, unlike other states, for purposes of pre-trial bond analysis, the presumption of innocence remains with the person accused of an offense, even a capital offense, from arrest and even during trial. See Vanderford v. Brand, 126 GA, 6770, 54 SE, 822. That means prior to and during trial, courts view the criminally accused to be innocent of the charges waged against him/her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecution proves guilt beyond a reasonable doubt. 2 ABA Standards for Criminal Justice 10-1.1. Comment. Thus, the granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. See Stack v. Boyle, 342. US 1 4 SCT 1 96 L 3. In order to protect our firm foundational belief that the one accused is presumed to be innocent prior to a finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing this honorable court that there are no set of conditions or circumstances that can be ordered to permit Mr. Williams' pretrial release on bond. 2 ABA Standards for Criminal Justice 10-5.100 Sup. 1986. The state bears the burden of proving by clear and convincing proof that pretrial detention is warranted. Ayala v. State, 262, GA, 704, 425 seconds E 282. This requires the prosecution to carry the burden of proving, by preponderance of the evidence, that this honorable court must deny Mr. Williams's motion for bail outright, rather than set bond with conditions of same in order to ensure Mr. Williams' presence in court and to protect the community. See Ayala v. State, 262 GA, 704, 425 seconds E 282. It is so significant to deny M.R. Williams' pre-verdict bond that the Honorable Supreme Court of Georgia requires this honorable court to specifically explain why no bond could be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. See Lane v. State, 247 GA, 387, 389, 276 SE 644. When considering pre-verdict bond, alleged guilt is extraneous, is completely irrelevant, and not considered for the pre-verdict bond analysis, as supposed guilt has no place in the bail proceeding since Mr. Williams is presumed innocent. Cowards v. State, 266 GA, 191, 465 seconds E 677. Yorker v. State, 266 GA, 615, 469 SE 158. Our highest court explained that in a bond hearing, Mr. Williams bears the initial burden of producing evidence that he would not pose a significant risk to flee the jurisdiction and would return to court when required, not be a significant threat or danger to the community or to any person or property. 2. In the community, 1. Not be a significant risk to commit a felony while on bond, and not be a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. See Ayala v. State Supra. Mr. Williams is not a flight risk. To meet this burden, Mr. Williams must first present evidence showing his roots in the community, which would include the length and character of residence in the community, employment status, and past history of responding to legal process. See Dunn v. Edwards, 257 GA, 458, 569 seconds E 525. Mr. Williams was born and raised in the Jonesboro South section of Atlanta, Georgia. Since birth in August 1991, Mr. Williams has maintained residence in Atlanta, Georgia. Although Mr. Williams has traveled the globe, has performed his music and artistry in every continent, save Antarctica, he always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Mr. Williams returned to Atlanta, Georgia from the country of Norway. Mr. Williams is one of 11 children, and he is the father of 6 children, ages 16, 13, 12, 11, 9, and 9. All of Mr. Williams' family lives in the Atlanta, Georgia area, including his parents. There is not many among us who has stronger roots in our community than Mr. Williams. Mr. Williams has been working since he was 6 years of age. At age 14, when the trial court makes a finding concerning a supposed threat to the community, this finding is the equivalent to whether the accused would be a significant risk to commit a crime. See Williams v. State, 228 GA, App 289 491 seconds E 500. 3. Was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Mr. Williams was signed by Atlantic Records and was paid $1 million. Mr. Williams is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Mr. Williams has demonstrated a strong history of lawful employment. Mr. Williams has appeared in courts in the past, represented by undersigned counsel Brian Steele for approximately a decade. To wit, Mr. Williams' entire adult life, Mr. Williams has never missed nor been late for a court appearance. Mr. Williams has a history of responding to the legal process. Undersigned counsel is in possession of Mr. Williams' passport and has permission to surrender this passport as directed by this honorable court for purposes of bond. Furthermore, when a bonding company writes a bond for the criminally accused, that company takes financial risk in ensuring the criminally accused's presence in court. In the case at bar, free at last bonding company has agreed to write a bond set by this honorable court, and the representatives of free at last bonding company are motivated to keep track of Mr. Williams and prevent any possible flight. See Easy Out Bonding v. State, 224 GA, App 706, 481 SE 834. The bonding company is additional evidence that the accused will return to court when required to do so. Mr. Williams intends to present witnesses to testify at the renewed bond hearing. Specifically, Mr. Williams' parents, managers, members of his record label, childhood friends, business associates, and the like will be present in court to testify and/or show support for the 2. Mr. Williams respectfully requests a date certain to argue this renewed motion for bond so that out-of-state witnesses can be present to testify before this honorable court. 4. Granting of pre-verdict bond for Mr. Williams. Mr. Williams is not a significant threat to the community or to any person or property in the community. Mr. Williams has taken the initiative to secure the commitment of full-time off-duty sworn law enforcement officers to watch his home and secure him in his home 24 hours 7 days a week if house arrest is ordered by this honorable court as a condition of pre-verdict bond. Mr. Williams will also submit to wearing an ankle monitor if ordered by this honorable court. As a condition of pre-verdict bond, Mr. Williams will submit to a condition that any person who would visit him at his abode would have to be on an approved list provided to this honorable court, as well as the district attorney's office, and if the individual's name is not on this list, that person will be denied entry to his home. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer, and if the visitor does not agree to consent to this search, the person will be prohibited from visiting with Mr. Williams. Mr. Williams also agrees that any of his text messages, telephone calls, emails, or other forms of communication in any manner can be secured, and the information provided to this honorable court, if desired, as if Mr. Williams was in custody and on a recorded line. The cost of the 24-hour 7 days per week off-duty sworn police officer detail, as well as the cost of the ankle monitor, would be incurred by Mr. Williams. With these parameters in mind, it cannot be said that Mr. Williams would be a threat or danger to the community or any person or property in the community. Undersigned counsel will agree to meet with his home to continue to prepare for trial. The above conditions place Mr. Williams in custody in his home. C. Brown v. State, 314 GA, App 1, 723 seconds E 112. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Mr. Williams' home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. See Brown v. State, 314 GA, App. 1, 723 seconds E, 112. Ordering Mr. Williams to wear an ankle monitor and to be in total lockdown in his home is the equivalent to custody and confinement, and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Mr. Williams. See Brown v. State Supra. Since May 9, 2022, Mr. Williams endures the torturous conditions in the county jail, to wit 2 out of 24 hours a day locked into a small cement cell with no contact with another human being except when his counsel visits and in court proceedings, inedible food, living in squalor ant infested room, and unable to see any activity movement out of the cell's windows. Mr. Williams is not a significant risk to commit a felony while out on bond. Mr. Williams is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9, 2022, after the arrest of Mr. Williams on the original grand jury indictment and incident to the search. Drugs and guns were allegedly located in this home. At the time of this search, there were numerous people in Mr. Williams' home. This is because others live at this home more often than Mr. Williams, who 6 is at this home intermittently, as Mr. Williams has several homes in the Atlanta area. Thus, Mr. Williams is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered above. Since Mr. Williams is not a significant risk to commit a crime, he is also not a significant threat to the community, property, or person in same. C. Williams v. State, Supra. Mr. Williams is not a significant risk to intimidate witnesses or otherwise obstruct the administration of justice. Mr. Williams has suggested as a condition of bond that all of his calls, text messages, and other means of communication are to be monitored, save privileged communications, and additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate a witness or otherwise obstruct the administration of justice via electronic means. In today's times, the legislature has provided that ankle monitors are a humane method of incarcerating a criminally accused without the need for punishment that is endured by languishing in the county jail. See Brown v. State Supra. This honorable court's foremost consideration with fixing the amount of bail should be the probability that Mr. Williams, if granted bond, will appear at trial. See Hernandez v. State, 294 GA. App. SE. Mr. Williams is a respected, high-profile artist who has positively impacted lives of others who would otherwise never break the poverty line. Mr. Williams has made a tremendous positive impact in our community.
That's tough. Who wrote that? Salute to everybody in here. Tap the like button. I ain't playing. We got the news. The paperwork came out. It's not that old. So I brought it straight out. You know what I mean? Salute to Nikki.
Mr. Williams is a positive member of society. He will continue to lawfully and ethically fight these baseless charges, governed by the above facts and law. Mr. Williams satisfies all 4 prongs of the Ayala v. State, Supra, test. Mr. Williams satisfies these 4 bond factors, and thus, the burden of production falls 7 onto the prosecution, and the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Mr. Williams to be entitled to pre-verdict release whatsoever. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. 97. Indeed, the most important element of liberty is to be free from physical detention by one's own government. GA 853, 815 seconds E 903. Based upon the above, Mr. Williams must be granted a reasonable bond with conditions of same. Where
All right. So that's Brian Steele reinitiating the bond process and getting a new bond hearing. I don't know about the state's response on that yet. I don't know if the state responded. I don't think so. Nikki, let me know. This paperwork looked pretty fresh off the press. This one right here, I think it's, hold on, let me check. Yeah, this from 5/22. So this about an hour and a half old right here. So let me go to this other one. Let me see what the next one is. Stay tuned. Y'all tap the like button. Salute. Let's get 100 likes in here. Let's get some more people. Straight up, hold on. Let me get this other one real quick. Let me see what I got next. All right, let's go. Motion to restrict Woody. Is that what this is? Reconsideration of Copeland. All right, let's see what this is.
A file date July 23rd, 2020, 3:07 p.m. Che Alexander, clerk in the Superior Court of Fulton County, State of Georgia, State of Georgia v. Shannon Stillwell.
Defendant. Indictment number 22 SC. Judge Whitaker. Motion for reconsiderations regarding certain hearsay statements. Comes now Mr. Shannon Stillwell by and through undersigned counsel hereby files this motion for reconsideration in the above-styled case. In support of this motion, Mr. Stillwell shows as follows. 1. Mr. Stillwell is accused of multiple felonies, including Count 1, conspiracy to violate the Georgia RICO law, and specific substantive felonies. Mr. Stillwell is innocent of all of the charges against him. Mr. Stillwell is charged with the January 10, 2015, alleged murder of Donovan Thomas in Count 2 of this indictment. Mr. Stillwell is innocent of that charge as well. Kenneth Copeland, a witness called by the state, is currently on the witness stand. Mr. Copeland has never claimed to have any first-hand knowledge regarding the death of Donovan Thomas. Mr. Copeland did, however, meet with law enforcement several times in 2015. On June 10, 2015, in what was Copeland's fifth meeting with law enforcement in 2015, Mr. Copeland told law enforcement that he possessed specific information regarding the shooting death of Donovan Thomas. Mr. Copeland made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Mr. Copeland did not mention this information on any of the 4 prior meetings with law enforcement. 4. In his June 10, 2015 interview, Mr. Copeland told law enforcement that he picked up Demakion Garlington at a McDonald's restaurant on Cleveland Avenue. On the evening of January 10, 2015, Copeland reported that Garlington walked to his Copeland's car and, while the two men were briefly alone, Garlington told Copeland that they killed Nut. Copeland told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland told law enforcement that he interpreted Garlington's words and actions to
Holmes sound like he with the shit, don't he? Tap the like button. Salute to everybody in here. I appreciate it. Help me get to 100 likes real quick. Y'all like the readers? I mean, I'm chilling. I had to, you know what I mean? I like this dude right here. Pause.
mean that Mr. Stillwell, Mr. Kendricks, Mr. Justin Cobb, and Mr. Demise McMullen were all present for and all participated in a drive-by shooting of Donovan Thomas. Per Copeland, Demise McMullen entered his car shortly after Garlington and all communication about the event ceased. 5. Mr. Copeland is now a sworn witness for the state and is currently on the stand. On direct examination thus far, Copeland has not denied making this June 10, 2015, statement to law enforcement. Mr. Copeland has repudiated the contents and veracity of this prior statement, however. Copeland testified at trial that this conversation with Garlington never occurred and that he fabricated the event to get himself out of legal trouble.
Salute to Quan. You already, Quan.
Furthermore, Copeland has denied contextual clues surrounding the out-of-court statement, testifying that it was Mr. Stillwell. 1. It should be noted that Mr. Garlington is charged in this indictment. Garlington was severed from this trial, as he remained unrepresented into the winter of 2022. Garlington is not expected to testify at this trial, as his case is still pending. 2. Nut and Peanut were Donovan Thomas's nicknames.
They lucky he ain't supposed to testify, because I thought he, at the beginning of the trial, he was. She was stating his name in initials like Kenneth Copeland. I told y'all that before. She was saying his name like DG. I think he was going to testify, y'all. Real rap. And then he's seen the scope. That's just my opinion, though. I could be wrong.
And not Mr. McMullen, who got into the car with Copeland and Garlington that evening. 6. Stillwell has challenged the admissibility of Garlington's out-of-court statements on hearsay and confrontation clause grounds. Judge Glanville, who has since been recused from this case, ruled that these statements were admissible as statements of a company conspirator. This ruling does not comport with the U.S. Constitution or the Georgia Rules of Evidence. The plain text OCGA 24-8-801 requires not only that the proponent of the evidence establish the existence of the conspiracy,
and show that the statement was made during the pendency of the conspiracy, but that the proponent must also establish that the statement was made in furtherance of the conspiracy. Assuming that Garlington actually said these things to Copeland, these statements were not made in furtherance of the conspiracy.
Yes, sir. No furtherance. Tap the like button. Help me get to a Hunski. Salute to everybody in here. Good evening. This paperwork fresh off the press. Hit the Cash App. Salute to everybody in here. I appreciate you. If you're not subbed to the second channel, you should do that.
To find otherwise simply overlooks, disregards the plain language of OCGA 248 to 801 and the line of controlling cases that establish that statements that spill the beans, by definition, do not further a conspiracy. See generally Stafford v. State 312 GA 823. State 3. Mr. Stillwell, through undersigned attorney, filed a motion in Lyman on this matter on September 30th, 2022. Judge Glanville eventually considered brief argument and ruled on the admissibility of the statements. Defense counsel was unable to locate a written order regarding the admissibility of Garlington's alleged statements. 4. Garlington has never publicly acknowledged making these statements to Copeland, and that Copeland now denies that Garlington ever made these comments to him. 7. The state plans to elicit testimony from Copeland regarding Garlington's alleged statements. While Copeland is now denying that Garlington made any such statements, Copeland has openly acknowledged that he previously told law enforcement that Garlington made said statements. The state has attempted to improperly introduce the contents of Garlington's statements through recordings of Copeland's prior statements, including his June 10, 2015 interview. The state's method is improper for 2 reasons. First, Copeland has not denied making these prior statements, and therefore no foundation for prior inconsistent statements has been laid. Second, which is the focus of the motion, Garlington's statements to Copeland, even if uttered, were not made in furtherance of the conspiracy and therefore fail to meet the requirements of OCGA 24 to 8-801. Wherefore,
All right. So that was attorney Max Shard in representation for Shannon Stillwell, and he's filing a motion to say that basically question Woody's whole testimony, right? Well, reconsiderations for hearsay statements that he all previously had tried to get Glanville to throw out. So he's bringing in the Donovan Thomas conversation from McDonald's, and Shart is trying to get that thrown out. Not Woody's whole testimony. That's Brian Steele filed that motion to get Woody whole testimony thrown out so far. All right, so this is for the hearsay. And that means he doubling back because the other judge, Glanville, had not properly dealt with the situation. So they all sending in motions, y'all. They on attack mode. All right, hold on. I got more. You sent me the list. You was only able to get a few. It's a lot. How much they cost? Send me the price. Oh, Frog. No, Frog, you could come up and debate. You could debate with me, but I could title it like how I want. But if you want to come up on Discord and say it with your mouth, then you more than welcome to have your opinion. But if not, you just hating, respectfully. But if you want to come up on Discord and talk about the title, I got a question mark at the end. I smoked your boots. I smoked your boots. Now apologize. Apologize. Yeah. Look at you. You was froggy and jumped. Psh. Got hit by a truck. Damn. What you gonna do now, bro? You gonna apologize? You get it? I'm nice, bro. Give me my credit. Now what you gonna do, though? Now this to see if you a real dude. Now you gonna admit, oh, I ain't even peeped that, bro. Damn, bro, you got me, bro. I ain't even gonna lie, bro. I should have went all the way to the end of the title. I should have. Instead of trying to come in and crack slick with you. I should have, bro. I thought I was tough. Hold on, you ain't even put the U in there, first off. Why are titling the video, quote unquote, Young Thug getting bond, as if he's already gotten it? Y'all gotta stop with the corny. Ish. Wow. Title of the video, defendant. What? What? Bro, you lost, bro. Is you going to admit it or not, bro? Nah, don't retract. You ain't got to retract, bro. Apologize, bro. You out of pocket, bro. But look, right, I ain't even mad at you, bro. Go about your way, bro. I don't even know why you wasted time if you thought I was spinning. I don't spin. But hit my Cash App, though. Salute the quantity, though. You heard? Yeah. Try again, cuz. Yeah. Yeah. You ain't gonna keep it real with me, though.
July 23rd, 2024,
You ain't gonna keep it
4:41
real, though.
p.m. In the Superior Court of Fulton County, State of Georgia. State of Georgia v. Jeffery Williams et al. Indictment number 22 SC Judge Pay.
You ain't grateful that I bought the paperwork to you immediately or nothing, bro. Golly, bro. Gee whiz. But respectfully, salute to you for consuming the content.
State's
and being
motion to
ungrateful.
restrict extrajudicial.
I hope your kids don't grow up and be like that. I hope they have manners. I hope they have manners. Ugh.
Judicial statements
I've
comes
been
now
in
the
this
state.
game for years. It made me an animal. It's rules to this. I done wrote me a manual. Step-by-step booklet for you to get your game on track. Not your wig pushback. Rule number uno. Yo, try again, cuz. Yo, you think I'll pop up here with this with this cardigan like this, cuz? And this jumbo brown bow tie, cuz? Just all willy-nilly. And let somebody like you really be able to just walk up on me like that, cuz. Nah, cuz. Try again, cuz. You heard? You heard? You. Tap the like button, y'all. Put a 1 in the chat. For real, we smoking boots this evening.
Of
It's
Georgia
easy.
and moves this honorable court to instruct the defense to refrain from making further extrajudicial statements about this case moving forward. Georgia Rule of Professional Conduct Rule 3.6 prohibits lawyers participating in litigation from making extrajudicial statements a reasonable person would believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. One irrelevant factor in determined prejudice is the nature of the proceeding involved, with criminal jury trials being the most sensitive to extrajudicial speech. 3. The character, credibility, reputation of a party for and any opinion as to the guilt or innocence of a defendant. 5 are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. Defendant Williams counsel attorney Brian Steele and Keith Adams defendant Kendrick's counsel attorney Doug Weinstein and defendant Stillwell's counsel attorney Max Shart have all made extrajudicial statements to the media explicitly discussing this case in violation of Rule 3.6. The extrajudicial statements have included, among other things, interviews and statements to the Associated Press. 4 of those interviews have been 25, 33, 43, and 107 minutes in length. The statements include, among other things,
Oh. Who this filed by the state? Oh, this different right here. This the state trying to get at the lawyers for going around talking. Oh.
the attorney's views and opinions about the case itself, opposing counsel, the judge, the jury, the outcome, and the guilt or innocence of specific defendants. Pursuant to OCGA, 15 to 1-3 courts have the power to control, in the furtherance of justice, the conduct of its officers and all other persons connected with the judicial proceeding before it, in every matter appertaining thereto. The state thus moves this honorable court to instruct the defense to refrain from making extrajudicial statements about this case moving forward. Respectfully submitted this 23rd day of July 2024. Below, please find Brian Steele's statement regarding the recusal order. Jeffery Williams is innocent of the charges brought in this indictment, and to clear his name he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Judge Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Mr. Williams' case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. Exhibit B exclusive. Young Thug's attorney speaks out on Glanville recusal. Keith Adams. Exclusive. Young Thug's attorney speaks out on Glanville recusal. Keith Adams. Complete interview. Exclusive. Young Thug's attorney speaks.
Whose video is that? Now they're using these other bloggers that's talking to the lawyers. So that's why they said something about this. Remember, somebody sent me an email and said, yo, they ready to stop doing interviews with certain people because they said it's crossing the line of such and such, such and such. So somebody sent the warning out about this, y'all.
1623, 362343, Exhibit C. The Associated Press reached out to Glanville and to a lawyer for Young Thug seeking comment on Monday's ruling. A spokesperson for Willis's office declined to comment. While I respect Chief Judge Glanville and his service to this community and the country, he simply became biased over the course of his case, Kendrick's lawyer, Doug Weinstein, said in an email. He added that he looks forward to trying the case before an unbiased judge, but said the only just outcome at this point is a mistrial and bond for Kendrick, who has been jailed for more than 2 years. Exhibit D. Judge Glanville recused. Attorney Doug Weinstein discusses live with journalist Megan Cuniff. Judge Glanville recused. Attorney Doug Weinstein discusses live with journalist Megan Cuniff. Complete in.
They all part of the play. Everybody name that get mentioned in paperwork as a YouTuber or a blogger is like seem like they've been placed, y'all. Y'all notice how many, like the ones that have been mentioned, it's never some offshoot dude. It's always the main line, y'all. I swear, it's something weird. Hold on. Doug Weinstein running around ready, throw the case out. Look, they all of his. Oh, Max Short talking to Megan. They ain't even hardly say nothing either. They taking small clips. They taking 12-second clips like they quoting them like they lyrics, y'all. That's crazy. That's crazy, though. Tap the like button. We got more. What's up? Let me see. Yeah, that's all of that one. Gee whiz. Ooh. Oh. All right, y'all. So apparently, Nikki sent me a list of all of the motions they filed. So they filed a motion for mistrial with no retrial. And 3 people filed motions for that. All right. 3 people filed motion for bond. The state filed a motion to stop the attorneys from speaking about the case in the media. The state filed a motion to forbid bad character evidence from defense about Donovan Thomas. A motion to disqualify prosecutors Love and Hilton. Yeah. If y'all can see if y'all can find a motion so I don't have to buy them. Them some of the ones I couldn't get, but I still got more. Hold on. All right, so here we go. A Shannon Stillwell one. Let me see what it is. Hold on, let me check the chat. Tap the like button. Did I read this one already? No.
E-file DLD, July 23, 2024, 3:07 p.m. Motion for fair and constitutional trial. Comes now, Mr. Shannon Stillwell, by and through undersigned counsel, and hereby files this motion for fair and constitutional trial in the above-styled case. In support of this motion, Mr. Stillwell shows as follows. 1. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and substantive felonies in this indictment. Mr. Stillwell is factually innocent of the charges against him. Like all citizens, Mr. Stillwell is guaranteed a fair trial and due process at trial by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. The state is seeking a life without parole sentence for Mr. Stillwell if he is convicted. And Mr. Stillwell's constitutional rights must be protected without exception. 4. Mr. Stillwell and his company defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of this trial. 5. Judge Earl Glanville has been the trial judge to this point. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. The defense also takes issue with several of Judge Glanville's legal rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801. Most recently, Fulton County District Attorneys Hilton and Love took part in an ex parte meeting with Judge Glanville. This meeting also included witness Kenneth Copeland and Copeland's attorney, Kayla Bumpus. Neither Mr. Stillwell nor undersigned counsel were informed of or invited to attend this meeting. The same is true for all of Mr. Stillwell's co-defendants and their counsels. 6. Kendrick filed a motion to recuse Judge Glanville on June 12, 2024. Judge Glanville summarily denied said motion. Kendrick's motion to recuse, as well as a similar motion filed by co-defendant Williams, were subsequently considered and granted by the Honorable Judge Rachel Krause. Mr. Williams, through his attorney, has since filed a motion for a fair trial on July 10, 2024. Williams' motion alleges and discusses several ways in which this trial has been unfair and has failed to meet constitutional requirements for Mr. Williams. Mr. Kendrick, through his attorney, has also filed a similar motion on July 23, 2024. Mr. Stillwell adopts both motions and incorporates their contents into this motion, as Mr. Stillwell has been similarly affected by the errors in this case. 8. Mr. Stillwell does not wish to demand a mistrial absent jeopardy attaching. Mr. Stillwell has been incarcerated since and has suffered through the duration of this case. Starting trial all over again is not a viable option for Mr. Stillwell. Furthermore, the defense has completely neutralized all testimony and documentary evidence presented against Mr. Stillwell thus far. In other words, the defense is winning this trial. The defense is winning despite the persistent legal errors, Brady violations, ex parte meetings, and discovery issues that have plagued this case. Mr. Stillwell does not request to start this case over. 8. Nonetheless, serious errors have tainted this trial and continue to prohibit Mr. Stillwell from receiving a fair trial and from confronting witnesses called. In other words, the defense is winning this trial. In other words, the defense is winning this trial. In other words, the defense is winning this trial. In other words, the defense is winning this trial. The defense is winning despite the persistent legal errors, Brady violations, ex parte meetings, and discovery issues that have plagued this case. Mr. Stillwell does not request to start this case over. 8. Nonetheless, serious errors have tainted this trial and continue to prohibit Mr. Stillwell from receiving a fair trial and from confronting witnesses called against him. Mr. Stillwell's due process rights have been and continue to be violated. These errors, as described in detail in the Williams and Kendrick motions, 1. have been caused solely by the Fulton County District Attorney's Office and Judge Glanville. These errors cannot be cured by curative instructions and will ultimately prevent these proceedings from meeting federal and state constitutional requirements, adhering to the Georgia Rules of Evidence, and fulfilling the requirements of Brady. 1. Mr. Stillwell specifically incorporates past and future filings on behalf of co-defendant Williams and co-defendant Kendrick, and the lists of legal error, prosecutorial misconduct, Brady violations, discovery violations, and other legal arguments included therein. Wherefore, undersigned counsel respectfully requests.
Bro, he talking that talk, bro. He talking heavy, y'all. Tap the like button, bro. That's what we was trying to hear right there. That type of mojo. That's what you need. If you waking up and you need some coffee, man, that's what you
AFLDAP
need
date,
right there, man.
July 23rd, 2020, 4:11 a.m. Shea Alexander, clerk, in the Superior Court of Fulton County, State of Georgia, DeMonte Kendrick, defendant. Against case number 22 SC, DeMonte Kendrick's motion for mistrial comes now DeMonte Kendrick by and through his undersigned counsels and brings this motion for mistrial showing as follows. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict, whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act, or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But, after all, they have the right to order the discharge, and the security which the public have for the faithful, sound, and conscientious exercise of this discretion rests, in this, as in other cases, upon the responsibility of the judges under their oaths of office. Jones v. State, 232 GA, 324, 327, quoting United States v. Perez, 22 U.S. 579, 580. The state has had witness after witness fail to provide the testimony that it would like the jury to hear.
Right.
Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its own witnesses, including at least the following key witnesses: Trontavia Stevens, Walter Murphy, Arkelian Bennett, Eduardo Nava-Flores, Adrian Bean, D'Angelo White, and critically, Kenneth Copeland. What is the state to do? Losing its case, apparently unconcerned about the need for public justice, the state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick that he would have no choice but to request a mistrial.
Kendrick.
Now, goaded by the state and the actions of Chief Judge Glanville, Kendrick has no option but to move this court for a mistrial to respect the constitutional rights of Kendrick and not defeat the ends of public justice. While this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. First, placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the point, the afternoon of June 12, 2024, when Kendrick moved Chief Judge Glanville to recuse himself, and he improperly failed to halt all proceedings pending determination of recusal.
Bro.
Since that date, the jury...
I spoke on that. I said, yo, I don't know why Judge Glanville not just stopping the case, because that motion said he's supposed to stop. Then everybody got caught up with Caleb Bumpus. I told y'all the Weinstein paperwork was in before hers, and it said that they were supposed to stop the trial, way more important than hers. Hers was for herself. Nobody wasn't paying attention. I said that. Tap the like button. Help me get to 200. We grinding. Straight up.
We heard days of testimony from Mr. Kenneth Copeland, testimony that can't be unheard. Second, Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret, ex parte meeting among the state, Chief Judge Glanville, Copeland, state investigators, court staff, and deputies. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Copeland to testify. None of the above 3 reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. Background. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in state against DeMonte Kendrick et al., 22 SC. Jury selection took more than 10 months with trial before the selected jury beginning November 2023. A secret ex parte proceeding was held on June 10, 2024. In attendance were Chief Judge Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, court staff, and members of the Fulton County Sheriff's Office. A central figure, perhaps the central figure, in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. On Friday, June 7, 2024, Copeland was sworn in. After being given a grant of immunity and being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the Fifth. Copeland was held in contempt and ordered incarcerated by Chief Judge Glanville. On that date, Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10, 2024, at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Defense counsel were told to be present in court at that time. Unknown to any member of defense counsel, an ex parte proceeding was held in Chief Judge Glanville's chambers on that date. Among the attendees were Chief Judge Glanville, Ada Love, Ada Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, court staff, and Copeland's attorney, Miss Kayla Bumpus. No member of defense counsel was present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights and the meeting being a critical phase of the trial. Neither Chief Judge Glanville, any member of court staff, nor the Fulton County DA's office made any member of defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. Several defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Chief Judge Glanville nor from the DA's office. Critically, Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. A review of the recently released transcript of the ex parte proceeding reveals the occurrence of the following events. Copeland announced that he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Chief Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Copeland was informed that there were over a dozen defendants left to try, following the above coercive actions by Chief Judge Glanville working in concert with the state. Sworn witness Copeland stated at the ex parte proceeding that he would testify. Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Copeland stated that he would lie on the stand. The state never gave Kendrick these critical Brady materials. These troubling facts not only implicate Chief Judge Glanville in an impermissible effort to join forces with...
Tap the like button, y'all. Help me get to 200. Come on, y'all. I'm downloading and going through there's a lot of paperwork. Come on, y'all. Tap the like button. Salute to Nikki for getting the paperwork. Help me get the likes up real quick. Hold on. Come on, man. Let's get a like break. Not a lunch break, a like break. Come on, man. Come on, man. And we got more paperwork to go, man. Come on, man. Get the 200 up there. Salute to everybody in the chat, though. Good evening. I appreciate you being here. Yeah.
The state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Following the secret ex parte proceeding on June 10, 2024, petitioner filed and presented a motion to recuse an accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied instanter, with a formal order issued on June 14, 2024, despite meeting all requirements of Uniform Superior Court Rule 25. The motion for recusal was summarily denied without following the required procedure of USCR 25.3. A formal order denying the motion was entered on June 14, 2024, 2 days after the motion for recusal was filed. On July 1, 2024, Chief Judge Glanville reversed his order of June 14, 2024, and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. On July 15, 2024, Judge Krause recused Chief Judge Glanville. Mistrial is required as all proceedings after June 12, 2024 are void. This honorable court is now faced with the unenviable and impossible task of rewinding the case to the afternoon of June 12, 2024. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. Props v. Morgan, 288 GA. 862-864. Kendrick moved Chief Judge Glanville to recuse during the afternoon of June 12, 2024, and he denied that motion. Critically, Chief Judge Glanville failed to follow USCR 25.3 by not halting proceedings and sending the recusal motion to another judge to rule on the recusal. Subsequently, Judge Krause, on July 15, 2024, found that Chief Judge Glanville should have been disqualified. Therefore, under Probst, all proceedings since the afternoon of June 12, 2024 are invalid and have no effect. This honorable court is now saddled with the repercussions of Chief Judge Glanville's failure to follow Rule 25. He should have halted all proceedings as required under Rule 25 and referred Kendrick's motion to recuse for assignment to another judge. Nevertheless, he persisted. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days. The remainder of the day on June 12th and on June 13th, June 14th, and June 17th. During that time, Chief Judge Glanville, who should have been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questioning of Copeland. Now, this court is tasked with unringing the bell. How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days from the jurors? How can the jury unhear days and days of testimony? This is not a matter of a witness uttering a single statement that a court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed.
I don't think they could get past this.
Instructing someone to not picture flying elephants only results in the listener conjuring images of Dumbo. Given the impossibility of erasing the proceedings since June 12, 2024, proceedings that are void due to the state knowingly, improperly requesting Chief Judge Glanville to hold an improper ex parte meeting with a sworn witness, and Chief Judge Glanville subsequently failing to halt proceedings as required by USCR 25-3. This honorable court has no alternative but to declare a mistrial. This motion for mistrial would not exist absent the state requesting the improper ex parte proceeding. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick into this position. Mistrial is required as the June 12, 2024 secret ex parte meeting was at a critical stage and violated Kendrick's rights. Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret ex parte meeting among the state, Chief Judge Glanville, Copeland, state investigators, court staff, and deputies. Defendants were not provided notice of the hearing. Under both the federal and state constitutions, a criminal defendant has a right to be present during critical stages of his trial. Allen v. State, 310 GA, 411, 418, 851 SE 541. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. A critical stage is one in which a defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Brennan v. State, 868 SE 782, 787. Here, the outcome of this case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. Copeland is the key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas. While the case against Kendrick is weak at best, even with the testimony of Copeland, without Copeland, the state has virtually nothing attaching Kendrick to the murder of Thomas. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick had a right to participate. A mistrial should be ordered by this court, given that Chief Judge Glanville denied Kendrick's constitutional right to be present at a critical stage of the trial, the ex parte meeting with Copeland. Furthermore, this mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Kendrick into moving for mistrial. Mistrial is required as Chief Judge Glanville tainted the proceedings by improperly coercing Copeland to testify. Copeland's testimony is tainted by the improper meeting prompted by the state, where Chief Judge Glanville wrongly coerced Copeland to testify. Chief Judge Glanville's coercion of testimony by sworn witness Copeland, in the face of Copeland's repeated refusal to testify and Copeland's statements that he would lie on the stand, was an act of impermissible intimidation and a violation of the Judicial Code of Conduct. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions, and the state's actions in working with Chief Judge Glanville on the coercion has intentionally goaded Kendrick into the only possible outcome, this motion for mistrial that should be granted by this court. As a natural result of the state's actions, Chief Judge Glanville has violated multiple rules of the Judicial Code of Conduct, the violation of which denied Kendrick's constitutional rights to due process and a fair trial. As requested by the state, Chief Judge Glanville held an improper ex parte proceeding conducted with sworn witness Copeland. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.92 of the Georgia Code of Judicial. 1 Uniform Superior Court Rule 4.1 generally prohibits ex parte communications. Except as authorized by law or by rule, judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. City of Pendergrass v. Skelton, 278 GA, App, 3739, 628 seconds E, 136. 2 GA, Code of Judicial Conduct 2.9, assuring fair hearings and averting ex parte communications provides. Judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties, or their lawyers, concerning a pending proceeding or impending matter, subject to the following exceptions. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provision promptly to notify all other parties of the substance of the ex parte communication, and gives the parties an opportunity to respond. Judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court, if they give notice to the parties of the person consulted and the substance of the advice, and afford the parties reasonable opportunity to respond. Conduct which assures every person a fair hearing. Ex parte communications are presumed to have been in error. City of Pendergrass v. Skelton, 628 seconds E, 136 278, GA, App, 37. Likely prompted by the state, not only did Chief Judge Glanville fail to notify defense counsel about the ex parte proceeding as required by Rule 2.9, but Chief Judge Glanville made every effort to conceal the proceeding. Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. Wynn v. State, 228 seconds. 378, 381, 139 GA. App, 355. See also Benton v. State, 58 GA. App, 633, 199 seconds E, 561. The situation of the present case is analogous to the situation in Webb v. Texas, 409 U.S. 95. While in Webb, a trial judge intimidated a defense witness into not testifying. The corollary is present here where a trial judge, chief judge, judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities, or with other judges provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record, and does not abrogate the responsibility personally to decide the matter. Judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic, problem-solving, or accountability courts, including drugs courts, mental health courts, and veterans courts. Glanville intimated a state's witness into testifying. The Supreme Court's language in Webb is instructive. In reversing a conviction, the Supreme Court said that, in light of the great disparity between the posture of the presiding judge and that of a witness in these circumstances, the unnecessarily strong terms used by the judge could well have exerted such duress on the witness's mind as to preclude him from making a free and voluntary choice whether or not to testify. ID at 98. That same disparity occurred with Copeland, a trial judge in his chambers in cooperation with prosecutors, surrounded by investigators and law enforcement, coerced Copeland with the threat of years of jailing. The state and the judge exerted such duress to preclude Copeland from making a free and voluntary choice whether to testify. Thus, Kendrick, who was neither present nor represented in the ex parte meeting, was deprived of his 14th Amendment due process rights. As in Webb, this court can't repair the infringement of due process rights under the 14th Amendment. Regardless of whether the violation was under Webb or Wynn, Kendrick's rights were violated by the judge's intimidation and coercion of Copeland. As the state likely expected, Kendrick has now been goaded into seeking a mistrial because of this due process violation and regretfully requests a mistrial. Wherefore, Kendrick respectfully and regretfully requests this honorable court to declare a mistrial based on the practical impossibility of avoiding the case after June 12, 2024, the violation of Kendrick's rights by his being absented at a critical stage of the proceedings, and/or the tainting of the testimony of Copeland by the improper coercion of his testimony by Chief Judge Glanville. Furthermore, Kendrick respectfully requests this honorable court find that this request for mistrial was goaded by the state when it requested that Chief Judge Glanville hold the ex parte meeting, absented Kendrick from the meeting, and joined with Chief Judge Glanville in the coercion of Copeland. This the 23rd day of July 2024. Respectfully submitted. Douglas S. Weinstein. Douglas S. Weinstein, Georgia Bar number 740-6498, attorney for petitioner. C. J. Abt E. J. Abtabarno, attorney for petitioner. The ABT Law Firm, LLC, Park Lake, Dr. Nee Suite, Atlanta, GA phone. Kadia Hingerty, Georgia Bar number 140-967, attorney for petitioner. The Hingerty Law Firm, Park Lake, Dr. Nebraska Suite 525, Atlanta, Georgia, 3525 phone. 678-644-9757 in the Superior Court of Fulton County, State of Georgia.
All right, my bad, y'all. I was looking for the rest of the paperwork. Nikki, I don't see some of that paperwork in Thug folder. I don't even see some of it. But what y'all think about that? What y'all think? But yo, salute to all y'all, man. This stream ain't gonna be long. I'm out of here, right? I just wanted to bring y'all that paperwork. If I get the rest of it, I'm gonna bring it back. Let me go in and do my research. I ain't gonna have y'all on hold. Salute to everybody. Tap the like button if you're watching it on the playback. Subscribe to the channel. I appreciate y'all. I appreciate the cash apps, the super chats, and the new members. Any new followers or whatever, you already know. I'll be back.